Let's be on the record in case number 2019 CR 1170, captioned State of Kansas versus Robert Freeman. Would the parties announce their appearances, please?
May it please the court, Karen Whitman for the state.
Your Honor, Mr. Freeman appears on video in custody with counsel Vincent Rivera.
All right. Well, this hearing was set down today for a bond motion on the 2019 case. My understanding is there's a revo case on his old one too that might impact what we do or the outcome of what we do today. So Ms. Whitman is here, I think, prepared for both cases. But Mr. Rivera, it's your motion. Would you like to be heard this afternoon?
Yes, sir.
Sure, go right ahead.
Judge, as I believe, as the court just noted, he has a pending felony aggravated crim threat and a pending probation violation on a DUI. Bond, he does not have a bond for his PV, and his bond is set at $25,000 in the pending criminal case. Judge, I'd cite the statute there that assures that people, regardless of their financial situation, should not be needlessly detained pending their appearance or answering for charges. A bond in the amount of $25,000 is unattainable for him to make. We're requesting the court to set a $5,000 bond in each case. This would put it at about $10,000, and his family would have to come up with $1,000. I think we're not asking you to let him out for free. I think $1,000 would be a significant investment for his family, and it would be enough to ensure he's coming back. I would also add, we were set for trial in this case on April of this last year, which obviously was kind of right in the middle of this pandemic. So this case is kind of in one of the poster child for cases that would have been resolved by now had the pandemic not happened. I would also add one thing I did not put in my motion. His family, they're currently spending about $300-400 a month on commissary. So that's an additional financial strain on his family of him being in custody. If he gets out, he's going to be able to try and get back to work. He was working at a temp agency prior to this. So Judge, we're just request the court to set his bond at $5,000 for each case.
Ms. Whitman.
Judge, in looking at one of the things concerning a bond is that whether he will show up or not, but also the public safety. If you look at the violations of my probation violation case, he is using illegal substances. He is not reporting. He is not. He completed a substance abuse program, but he was supposed to go and do an intense outpatient treatment program, and he never did. And so then we started using PCP again, and the violations say that happened May 16th of 19, May 30th of 19, June 14th of 19, August 8th of 19, and then this new case, the case that we're waiting for jury trial, happened October of 2019. There is reason that for his own safety and our public safety, because it was a second-time DUI on the probation violation case, that he remain in custody. His past performance is a good sign of his going forward performance. And at this point, he has shown to be a danger by having an aggravated criminal threat charge now pending. Therefore, we don't see why there is any reason to change his bond at this point.
All right. What's his backup time on his DUI?
I think it's about a year.
Yeah, the underlying sentence was a year. I do know that, as I'm trying to look and see what he did.
You mean jail credit?
Yeah, just the original
So at
sentence.
sentencing,
He had 70 days
yeah.
credit when he got sentenced.
All right. So we had let's call it 2 months when he got sentenced. And when did he go in on this new case? October?
That would have probably been right around that October date.
Right. So that's another,
He's probably almost done
yeah,
with the underlying sentence.
right.
And that's why I was asking Mr. Lindstrom, who's on the Zoom hearing from Court Services, to figure out what, because I believe the last hearing, you, Judge, had asked that we get a probable criminal history score, because it looks like he might have a lot of misdemeanors that would aggregate.
Right.
And so that way, and we have already offered a couple different options and pleas. I know they were read into the record last time, but it would really solidify exactly what his criminal history is for the plea offers.
All right. So let me look, here's the issue that I have. And it's certainly not the state's fault, and it's not the defendant's fault, that's for sure. That, we should have had a resolution one way or another sometime in April, where he would be either doing time or released on probation on all of this stuff. Yet we're sitting here with no real prospect of having that case decided whatsoever. Meanwhile, he's getting ready right now to zoom past the sentence that he would be in otherwise. So let's say I deny his motion for a bond reduction. He's not able to make a $25,000 bond. I think that's pretty clear. So we're sitting with him in custody till, I don't know, January, February, March. It just doesn't seem fair to him. It doesn't seem like a resolution that, look, if I thought he's going to get revoked on his DUI today and he's got to go give us 6 months, then there's no reason to let him out, turn around and put him back in for 6 months in a couple of weeks or a month or whatever. But he's about flattened that time out. So I'm going to try and not consider the probation violation right now. As far as him being held, would he be held on this ag criminal threat for this period of time without the circumstances we find ourselves in? I think it's important. The ag crim threat is not a domestic violence situation or anything like that. He was alleged and probable cause was found at preliminary hearing that he telephoned the jail with a bomb threat. And that's the basis of the charges. I don't see that he's a particular danger given that, but here's how I think I can address assurance that he shows up and public safety. I'm going to reduce his bond to $500 in each case, cash or surety, so that if they can come up with $1,000, I think his family would be motivated to make sure that he appears in court. One of the specific requirements of his bond is going to be compliance with his probation. That means he has to report. That'll kind of take the place of pretrial services, and he has to drop. Here's where I think we can have a difference. If he was out free and I was making him come in and drop, then it could just be a process of him not having successfully completed treatment. He's clean right now, I assume, since he's been in jail for 8 months, which means if he comes out and starts testing dirty right away or quickly without getting into some sort of treatment, then that really tells me all I need to know. And Mr. Lindstrom, if you will tell Mr. Campbell, one of the terms of his bond is him submitting clean UAs. So if he fails to submit or if he submits dirty, I want him taken into custody immediately because he's in violation of his bond.
Yes, Your Honor.
All right. And here's Mr. Brinkworth coming in, so maybe he'll want to hear this as well. So Ms. Whitman, I know that doesn't completely absolve the state of all of their concerns, but I think it does a fair job in addressing them without just frankly telling Mr. Freeman, sorry, you're bad luck. You're going to spend a year and a half in jail because we can't give you a jury trial. So Mr. Brinkworth, I'll just let you know what I've decided is I'm going to reduce his bond to $500 cash or surety in each case. Mr. Rivera believes that his family can come up with $1,000 to get him out. His term of bond is that he comply with probation and submit negative UAs upon request. Any failure to submit or a dirty UA will cause his bond to be revoked. I don't know if you wanted to add anything to that.
Judge, I'm pretty sure Ms. Whitman has probably already expressed the state's sentiments on this, so I don't think I have anything further.
Okay, all right. Mr. Freeman, I'm trying to be completely clear here, and I want to give you an opportunity to ask me or Mr. Rivera any questions or anything you're not clear about this court's order.
No. Only why I was dropping dirty because when I first got out of jail,
Hold on. It's kind
I'm
of
having a hard
difficult to
time.
understand you, so speak slowly and loudly, please.
only why I was dropping dirty then because when I got out of jail, I was going around seeing who to report to. Nobody didn't know nothing. Like the lady, she never told me who to report to. I went to the
Hey, Robert, don't worry about that. We're talking about the future. We'll
Yeah.
talk about the future.
Thank you, Mr. Rivera. Yeah, that's my point. I'm not worried about that other stuff. We'll take that up at another time and place.
Okay.
I just want to make sure that you're clear on what I'm requiring you to do.
Yes, sir.
All right. Mr. Lindstrom, what do you want Mr. Freeman to do when he gets out today? Or, well, I'm sorry, when he makes bond? You're muted.
Thank you. Sorry. As soon as he's released, Your Honor, he needs to call Jesse Campbell and schedule when he needs to report.
All right. You know how to get a hold of Mr. Campbell, Mr.
Yeah.
Freeman? Okay, then you make that bond. I need you to do that immediately, okay?
I gotta go to Missouri when I get out. So after I get out from over there,
What do you got going on in Missouri?
I just got a $250 bond over
Traffic thing or what?
there. Possession.
All right. Well. All right. Well, anyway, the court's order is going to stand. You keep in touch with Mr. Rivera. If you get picked up and held over there, we need to know that too.
Okay.
Because all it's going to do is cause a bench warrant to issue over here. And so they'll take you over there, they'll take care of you over there, and then we'll have to come and get you and bring you back here and all of that. All right.
Okay. That's why I brought it up for you to know.
All right. So that's my order today. I'm trying to figure out how to get the docket sheet to reflect the bond modification. Do you have a suggestion, Mr. Rivera?
No, Judge, I guess I just put the bond as a,
You want to draft up a proposed order and e-file it and I'll sign it today? That
Sure.
should do it.
and
I'll
also
make an ROA and notify the clerks as well.
Okay.
All right. Anything else for our record today?
Just to clarify, we don't have another setting on this yet?
No, not that I'm aware of.
Yeah, no.
Okay.
Well, here's what we need then. I mean, if I don't give him a court date
Right.
and he gets released on bond, let me see when my next Revo docket is.
Or
We'll
you could
put 'em
just
on
put it on
that.
your regular criminal docket, Judge.
That's right. We did that. Let me take a look at my calendar here real quick. And we're gonna give you a court date. August 25th at 9:30 in the morning.
Robert, do you think you can get in and out of Missouri by then?
Yeah, I should be able to. So what will I go to court at?
We just got to keep the train moving.
Oh, you talking about just being out at that time?
Judge,
Well,
can I ask, can we get set in September just to be
You
safe?
want a September setting? Yeah.
Please.
Let's see, how about the 15th at 9:30?
Great.
All right. 9:15 at 9:30 for a docket call. We'll put both of these cases on it.
Mr. Revere, you will know everything. I'll call you and let you know everything.
Okay. And
All
I'm
right.
gonna call. Is Brianna still 655-1464?
Yeah.
Okay, I'll give her a call once we're done.
Okay, that worked. Thank you.
Anything else for our record today?
No,
Nothing
Judge.
further,
Nothing from
Judge.
defense.
We're adjourned.